Before we begin, a quick and important disclaimer. This video is for educational and entertainment purposes only and does not constitute professional legal, financial, or tax advice. The division of retirement assets like a 401k involves complex federal laws under the Employee Retirement Income Security Act, commonly known as ERISA, as well as specific state statutes that vary significantly across the U.S. Sun Belt. Every individual case is unique, and the potential outcomes discussed here are based on historical trends and general case studies, rather than specific predictions. You should conduct your own due diligence and consult with a qualified family law attorney, a certified divorce financial analyst, and a tax professional before making any decisions regarding your retirement accounts or divorce settlements. We are not responsible for any actions taken based on the information provided in this deep dive. Imagine you have spent 35 years building a life in the heat of the Arizona desert or the humid suburbs of Houston, Texas. You have diligently contributed to your 401k through every market cycle, every promotion, and every economic downturn. You have watched that balance grow from a few $1,000s to a seven-figure nest egg, all with the vision of a quiet retirement in a Sunbelt paradise. Now imagine that entire vision evaporating in a single afternoon because of a phrase you never expected to hear: community property. In states like Texas, Arizona, Nevada, and California, the law does not care whose name is on the account or who earned the salary. The law views that 401k not as your personal safety net, but as a communal asset that belongs equally to your spouse. This is the reality of the Sun Belt divorce, a region where the population is aging, the migration of retirees is peaking, and the legal stakes for retirement accounts have never been higher. We are currently witnessing a phenomenon social scientists call the gray divorce. Since 1990, the divorce rate for Americans over the age of 50 has doubled, and for those over 65 it has tripled. Many of these couples are migrating to the Sun Belt for their golden years, only to find that their marriage cannot survive the transition into full-time retirement. When the marriage ends, the 401k becomes the largest battleground. If you handle this incorrectly, you could lose half of your life's work to your ex-spouse, and then lose another 40% of what remains to the IRS in the form of immediate taxes and early withdrawal penalties. This is not just a legal process. It is a mathematical minefield that can determine whether you spend your 70s in a comfortable condo or a studio apartment struggling to pay for basic healthcare. This deep dive masterclass is designed to solve one specific, high-stakes problem: how to navigate the absolute complexity of a 401k division in the unique legal landscape of the U.S. Sun Belt. We are going to deconstruct the myths of asset division, explain the mechanical reality of the Qualified Domestic Relations Order, and show you exactly how different states from Florida to California treat your retirement money. By the end of this series, you will understand the historical trends that govern these settlements, the case studies of those who lost it all, and the step-by-step logic required to protect your financial future. To understand the weight of this issue, we must first look at the geography of the Sun Belt and why it creates a perfect storm for retirement asset litigation. The Sun Belt is not a monolith. It is a patchwork of two very different legal philosophies: community property and equitable distribution. In states like Texas and Arizona, the starting point is often a strict 50-50 split of all assets acquired during the marriage. If you move to Phoenix from a state like New York midway through your career, your 401k is suddenly subject to a mathematical tracing process that is as tedious as it is expensive. Your lawyer must determine which portion of your 401k was separate property brought into the marriage and which portion became community property once you cross state lines. This is where many people fail. They assume that because they earned the money, it stays with them. In the Sun Belt, that assumption is a fast track to financial ruin. Consider a case study of a software engineer in Austin, Texas. He spent 20 years at a major tech firm, accumulating a 401k balance of $1.5 million. He married his spouse 10 years into that career. In a Texas court, that engineer does not simply keep his $1.5 million. The court will apply a characterization of the property. The funds contributed before the marriage, plus the passive growth on those specific funds, might remain separate. However, every dollar contributed during the 10 years of marriage, including the employer match and the interest earned on those contributions, is considered communal. Without meticulous record-keeping, meaning every statement from the last 2 decades, the court may default to the community presumption, meaning the entire $1.5 million is treated as joint property unless he can prove otherwise with clear and convincing evidence. This is the reality of the Sun Belt legal system. The burden of proof is on you to keep what you believe you earned. Moving east to Florida or Georgia, the rules shift to equitable distribution. Here, the court has the discretion to divide assets in a way that is fair, which does not always mean equal. Factors such as the duration of the marriage, the economic circumstances of each spouse, and contributions to the career of the earning spouse all come into play. A Florida judge might look at a 401k and decide that because one spouse gave up their career to raise children, they deserve 60% of the retirement account to compensate for their lack of future earning potential. This unpredictability creates a different kind of stress. In a community property state, you are fighting over math. In an equitable distribution state, you are fighting over a narrative. The mechanism that actually moves this money is called a QDRO, or a Qualified Domestic Relations Order. This is a federal legal instrument that most people have never heard of until they are in the middle of a divorce, yet it is the most powerful document in your financial life during this transition. A 401k is governed by ERISA, a federal law that generally prohibits the alienation of benefits. You can't just tell your HR department to give half your 401k to your ex. The plan administrator would refuse, citing federal law. The QDRO is the only key that can unlock the 401k without triggering the catastrophic tax consequences that usually follow a premature withdrawal. If you simply withdraw the money to pay out a settlement, the IRS treats it as a distribution. If you are under the age of 59 and a half, that means an immediate 10% penalty plus your ordinary income tax rate. For a high earner in the Sun Belt, that could mean giving 50 cents of every dollar to the government before your spouse even touches it. The promise of this masterclass is to guide you through these pitfalls. We are going to look at why the valuation date is the most contentious day in a Sun Belt divorce. If your 401k was worth $800,000 on the day you filed for divorce, but the market crashed and it's worth $600,000 on the day the decree is signed, who bears that $200,000 loss? In states like Nevada, the answer can depend on the specific language of your filing, and a mistake in timing can cost you a decade of savings. We will also explore the offset strategy. Sometimes the best way to handle a 401k in a Sun Belt divorce is not to touch it at all. If there is a primary residence in Scottsdale or a vacation home in the Keys with enough equity, you might buy out your spouse's interest in the 401k using that equity. But this requires an apples to oranges comparison. $1 in a 401k is not worth the same as $1 in home equity because of the embedded tax liability. When you eventually withdraw from that 401k, you will pay taxes. The house equity might be tax-free up to a certain limit. Understanding this discrepancy is the difference between a fair deal and a financial disaster. We are diving into the specifics of the Sun Belt because this region is currently the epicenter of American wealth transfer. From the tech hubs of the Silicon Slopes to the retirement communities of the villages, the stakes have never been higher. This video series is your roadmap to understanding how the law, the math, and the strategy intersect in the most high-stakes financial event of your life. We will cover the specific statutes of the Big Four Sun Belt states, Texas, Florida, Arizona, and California, and provide the technical depth you need to speak the language of your attorney and your financial advisor. We are moving beyond the surface-level advice you find on blog posts. We are going deep into the historical trends of how judges in these jurisdictions actually rule, and how you can prepare for the potential outcomes of your specific situation. This is part 1 of your deep dive into the 401k divorce in the U.S. Sun Belt. To transition from the legal theory of the Sun Belt into the brutal reality of the mathematics, we must start with the concept of characterization. In the year 2026, the financial landscape has shifted, but the fundamental question in a 401k divorce remains the same. What part of this money belongs to the marriage and what part belongs to you? In Sun Belt states like Arizona and Texas, courts apply the inception of title rule. This rule posits that the character of an asset, whether it is separate or community, is determined at the moment the asset is first acquired. However, a 401k is not a static asset like a plot of land in Sedona. It is a moving target of thousands of individual contributions and market fluctuations. Imagine a case study involving a character named Robert, a senior systems analyst living in Phoenix, Arizona. Robert began his career in 2012, long before he met his spouse. By the time he married in 2018, his 401k balance was $250,000. Fast forward to 2026, and the marriage is dissolving. The account is now valued at $1.1 million. Robert might assume that the $250,000 he walked into the marriage with is safe. In the eyes of the Sun Belt courts, he is only partially correct. and the burden of proof is entirely on his shoulders. This is where the forensic process of tracing begins. Tracing is the step-by-step reconstruction of an account's history to distinguish between separate and community funds. In a high-stakes Sunbelt divorce, a forensic accountant will use a method known as the clearinghouse or exhaustion method. They look at every single quarterly statement from 2018 to 2026. They are looking for commingling. If Robert ever rolled over funds from a previous employer's 401k into his current plan during the marriage, or if he took a 401k loan to pay for a down payment on the couple's home in Scottsdale, the lines between his separate property and the community property have been blurred. In Arizona, if the separate and community funds are so mixed that they cannot be clearly identified, the court may characteristically default to the community presumption. This means Robert's $250,000 head start could be legally swallowed by the marriage, resulting in a potential outcome where his spouse receives half of the entire $1.1 million. Historical trends in Sun Belt litigation show that the most contentious variable is not the contributions themselves, but the passive appreciation. Let's look at the mathematics of the growth. If the original $250,000 grew to $400,000 simply because the market performed well, that growth is typically considered separate property in many jurisdictions. However, if Robert was actively managing the account, day trading within his 401k brokerage link, or making strategic shifts that require significant time and effort during the marriage, a spouse's attorney might argue that the growth was the result of community labor. In states like Texas, the income generated by separate property, such as dividends or interest paid out into the 401k, is often classified as community property. This creates a nightmare for the person trying to protect their premarital assets. You aren't just calculating a split, you are performing a multi-year audit of market returns versus contribution timing. Another layer of complexity in the 2026 Sunbelt landscape is the employer match and the vesting schedule. Imagine a scenario where a marketing executive in Charlotte, North Carolina, a state that follows equitable distribution, has a 401k where the employer match takes 5 years to vest. If she worked for 3 years before the marriage and 2 years during the marriage before the match fully vested, how is that money divided? Sunbelt courts often use a time rule formula, sometimes referred to as a coverture fraction. The numerator of this fraction is the total months of participation in the plan during the marriage, and the denominator is the total months of participation from the start of employment until the date of divorce or valuation. Coverture fraction equals total months in plan, months of marriage while in plan. If our marketing executive was in the plan for 120 months total, and 60 of those months were during the marriage, the coverture fraction is 50%. This means 50% of the total 401k balance is considered marital property and subject to division. But what about the unvested portion? In 2026, many tech and aerospace companies in the Sunbelt have moved to complex vesting structures. Courts generally rule that even unvested benefits are a form of deferred compensation earned during the marriage. If the right to that money was earned while the couple was together, the spouse likely has a claim to it, even if the money doesn't technically exist in the account yet. The QDRO must be drafted with specific language to handle these future payouts, often using a deferred distribution method where the ex-spouse receives their share only when the employee actually vests and becomes eligible for a payout. Now, consider the volatility factor. We are currently in a market environment where 401k balances can swing by 5% in a single week. In a Sunbelt divorce, there is often a significant gap between the date of separation, the date of the trial, and the date the QDRO is finally processed by the plan administrator. Imagine if Robert and his spouse agreed to a $500,000 payout in June 2026. If the QDRO isn't finalized until September 2026 and the market drops 15% in the interim, Robert's account might not have enough liquidity to pay the $500,000 without depleting his own share disproportionately. To avoid this, professional scriptwriters and legal experts emphasize the use of percentage-based divisions rather than fixed dollar amounts. By awarding a percentage, the ex-spouse shares in the market risk and the market gains until the moment of transfer. We must also address the specific tax traps inherent in the Sun Belt. Because many retirees in Florida and Nevada are moving from high-tax states like California or New Jersey, they often arrive with massive 401k balances that have never been taxed. When dividing these assets, the court must account for the embedded tax liability. If one spouse takes the $1 million 401k, and the other takes the $1 million primary residence in Summerlin, Nevada, the trade is not equal. The house can often be sold with a significant capital gains exclusion, while every dollar taken out of the 401k will be taxed as ordinary income. In 2026, with federal tax brackets potentially shifting, that $1 million 401k might only be worth $700,000 after Uncle Sam takes his cut. A failure to tax suggest the division of assets is one of the most common ways people accidentally lose hundreds of thousands of dollars in a Sunbelt settlement. Step by step, the process of protecting yourself involves gathering every summary plan description from your employer, securing every statement back to the date of your marriage, and identifying any outstanding 401k loans. In the Sunbelt, a 401k loan is often treated as a community debt if the funds were used for a community purpose, like renovating a kitchen in a Houston suburb. If you are the one who took the loan, you might find yourself responsible for paying it back with post-divorce separate property, even though your spouse benefited from the money. This brings us to a critical realization. The 401k is not just an account. It is a legal contract governed by federal law that is being interpreted by state judges who have enormous discretion. We have covered the math of tracing and the coverture fractions, but there is a hidden variable that can override all of it. In the next part, we are going to look at the nuclear option of Sunbelt divorces, the impact of prenuptial and postnuptial agreements on ERISA-governed accounts. You might think your prenup protects your 401k, but federal law has a very different opinion on who can waive their rights to a retirement plan. If you don't know the difference between a spouse and a fiancé in the eyes of the IRS, your prenup might be nothing more than an expensive piece of paper. How do you ensure your 401k survives a challenge from a spouse who signed a waiver before the wedding? Why do Sunbelt judges often throw out these waivers when it comes to retirement accounts? And what is the one specific document you must sign the day after your wedding to make your prenup actually stick? We will dive into the collision of state contract law and federal ERISA law in the next part of this masterclass. The reason your prenuptial agreement might be a ticking time bomb in a Sunbelt divorce comes down to one word: ERISA. The Employee Retirement Income Security Act of 1974 is a federal law that governs almost all private sector 401k plans. In the hierarchy of American law, federal statutes like ERISA sit above state contract law. This creates a massive, often invisible friction point for couples in states like Nevada, Arizona, or Florida. You might have a signed, notarized prenuptial agreement that explicitly states your 401k is separate property, but if that document was signed before you said "I do," it might not be worth the paper it is printed on when it comes to your retirement account. To understand why this happens, we have to look at how ERISA defines a spouse and their rights. Federal law mandates that a surviving spouse has a legal right to at least 50% of a 401k account. Because ERISA only recognizes the rights of a spouse, and a fiancé is not yet a spouse, a fiancé cannot legally waive their future spousal rights under federal law. Historical trends in federal court cases have shown a consistent pattern. Judges frequently rule that a premarital waiver of 401k rights is invalid because the person signing it was not yet a spouse at the time of execution. Imagine a case study involving a character named Sarah, a high-level executive at a tech firm in Atlanta, Georgia. It is early 2026, and Sarah is preparing for a divorce. Before her marriage in 2020, Sarah had $500,000 in her 401k. She and her fiancé, James, signed a comprehensive prenuptial agreement. James specifically agreed that he would never seek a portion of Sarah's 401k, regardless of the length of the marriage. Sarah felt secure. However, as the divorce proceedings begin in a Georgia court, James's attorney files a motion to invalidate that specific clause of the prenup. The argument is simple. Under ERISA, James was not a spouse when he signed the waiver, therefore the waiver is federally deficient. Potential outcomes in this scenario often involve the court ignoring the prenup entirely regarding the 401k and defaulting to the state's equitable distribution laws, which could award James a significant portion of the growth that occurred over the last 6 years. This leads us to the critical step-by-step logic that many Sunbelt residents miss: the postmarital waiver. If you want a prenuptial agreement to actually protect a 401k, the spouse must sign a separate, federally compliant spousal waiver in consent form after the wedding ceremony has taken place. This is not just a simple signature. It is a formal document usually provided by the 401k plan administrator. It must be witnessed by a notary public or a plan representative. In the rush of a honeymoon and starting a new life in a new Sunbelt city, almost no one remembers to do this. But without this document, your 401k remains vulnerable to the community property or equitable distribution rules of your state, regardless of what your prenup says. The distinction between different types of retirement accounts is where the strategy gets even more complex. While 401ks are governed by federal ERISA law, individual retirement accounts, or IRAs, are typically governed by state law. This creates a bizarre legal double standard. If Sarah in our case study had rolled her $500,000 into an IRA before the marriage, her prenuptial agreement would likely have been fully enforceable under Georgia state law because ERISA does not apply to IRAs in the same way. However, because the money stayed in a 401k, she fell into the ERISA trap. This is a common historical trend in Sunbelt divorces where one spouse is a corporate employee with a 401k, and the other is a small business owner or contractor with an IRA. The level of protection they each have is fundamentally unequal from the start. Let's look at the data on how this impacts the division of assets. In 2026, we are seeing a rise in what is called the ERISA litigation surge. As more couples enter their second or third marriages later in life, the 401k is often their largest asset. When a prenup fails due to ERISA noncompliance, it doesn't just change the math. It changes the entire negotiation leverage of the divorce. If one spouse knows the 401k waiver is invalid, they can use that as a hammer to extract concessions in other areas, like the equity in a vacation home in Naples, Florida, or the division of a brokerage account. Now, imagine if you are the spouse who is being asked to sign a postmarital waiver. In a Sunbelt state like Texas, where community property is the law of the land, signing that waiver is a massive financial move. You are essentially signing away a future legal right to half of the marital contributions and growth. If you are a spouse who has stepped out of the workforce to support your partner's career, a very common scenario in the growing suburbs of Houston or Dallas, that 401k might be your only path to a stable retirement. This is why many family law attorneys in the Sunbelt now advise their clients to wait until after the marriage to negotiate retirement asset protections, though this obviously creates its own set of interpersonal tensions. Another factor to consider is the Summary Plan Description, or SPD, of the 401k itself. Every 401k plan is different. Some plans have very specific requirements for how a spouse must be notified or how a waiver must be filed. In 2026, many plan administrators have moved to digital-first platforms, but the federal requirement for a witness signature remains a point of friction. If you sign a waiver through a digital portal without a proper notary or plan witness, the court might still throw it out. We have seen case studies where a spouse signed a waiver on a mobile app, only for a judge to later rule that the lack of a physical witness made the waiver void under federal standards. The complexity deepens when we talk about the rollover trap. If you are in the middle of a divorce in a Sunbelt state, and you decide to roll your 401k into an IRA to try and gain more control or better investment options, you might be making a catastrophic mistake. The moment that money moves from an ERISA-protected 401k into an IRA, the legal protections and the way the account is characterized can shift instantly. If there is a standing order from the court, which is common in states like California or Arizona, moving that money could even be considered a violation of a court order, leading to sanctions or a larger award to your spouse. Step by step, the protection of these assets requires a three-pronged approach. First, you must have the prenuptial agreement as a statement of intent. Second, you must verify the character of the account. Is it an ERISA-governed 401k or a state-governed IRA? Third, you must execute the postmarital waiver the moment the marriage certificate is filed. Failure at any of these three stages creates an opening for a legal challenge that can take years to resolve and cost tens of thousands of dollars in legal fees. But even if you do everything right, even if your paperwork is perfect and your waivers are filed, there is one thing that can still wreck your 401k division: the drafting of the QDRO itself. Many people think that once the judge signs the divorce decree, the hard part is over. In reality, the decree is just a piece of paper that the 401k plan administrator can ignore if the technical language isn't perfect. If the person drafting your QDRO doesn't understand how to handle things like market volatility, dividends, or loan offsets between the date of the decree and the date of the payout, you could end up losing another 20% of your account simply through poor clerical work. How do you prevent a plan administrator from rejecting your QDRO and sending you back to square one? What happens if your 401k takes a massive hit in the stock market while you are waiting for the paperwork to clear? And why is the separate interest versus shared interest approach the most important decision you will make in the entire QDRO process? We are going into the technical weeds of the QDRO drafting process, where the real money is won or lost, in the next part of this deep dive. The transition from a signed divorce decree to actually seeing funds move from a 401k is a journey through a high-stakes bureaucratic labyrinth. While the judge's signature in a courtroom in Las Vegas or Miami feels like the end of the road, in the world of federal retirement law, it is merely the starting line. This is where we encounter the Qualified Domestic Relations Order, or QDRO. This document is the only legal bridge capable of crossing the gap between a state court's authority and a federal retirement plan's restrictions. Without a perfectly drafted QDRO, your divorce decree is just an expensive suggestion that a 401k plan administrator is legally obligated to ignore. To understand why this is so technical, you have to realize that the plan administrator, the person at the company who manages the 401k, does not work for you, and they certainly do not work for the court. They work for the plan. Their primary responsibility is to ensure the 401k remains compliant with the Internal Revenue Code and ERISA. If they approve a QDRO that contains even a minor technical error, they could jeopardize the tax-exempt status of the entire company-wide plan. Consequently, they are incentivized to be incredibly pedantic. Historical trends show that a significant percentage of QDROs are rejected on the first attempt because they lack specific language required by that individual plan's summary plan description. Imagine a case study involving Michael, a civil engineer working for a major infrastructure firm in Las Vegas, Nevada. In the year 2026, after 15 years of marriage, Michael and his spouse are finalizing their divorce. Their settlement agreement states that his spouse is to receive $400,000 from his $1.2 million 401k. Michael's attorney drafts a simple one-page order and sends it to the plan administrator. 2 weeks later, the administrator sends it back with a rejection letter. The reason? The order failed to specify whether the $400,000 should include pro rata earnings and losses from the date of the decree until the date of the actual distribution. In a volatile 2026 market, that distinction could represent a $40,000 difference in the final payout. This brings us to the single most important decision you will make in the drafting process: the choice between a separate interest and a shared interest approach. This is where most people, and even many general practice attorneys, make a mistake that haunts them for decades. In a separate interest QDRO, the court essentially carves out a piece of the 401k and hands it to the ex-spouse to manage as their own. The ex-spouse, known in legal terms as the alternate payee, gets their own account number. They can choose their own investment allocations, and most importantly, they can often roll that money over into their own IRA immediately. This effectively severs the financial tie between the two parties. For 401k plans, the separate interest approach is almost always the preferred method in the Sunbelt because it allows for a clean break. Conversely, a shared interest QDRO is a relic usually reserved for traditional pension plans, but it occasionally incorrectly finds its way into 401k divorces. In a shared interest scenario, the ex-spouse does not get their own account. Instead, they simply receive a portion of each payment the employee receives when they eventually retire. If you are the ex-spouse and you are stuck in a shared interest QDRO for a 401k, you are at the mercy of the employee's retirement date. If Michael decides to work until he is 75, his ex-spouse might not see a dime of that 401k money until then. In 2026, as the retirement age continues to trend upward in the U.S., being tethered to an ex-spouse retirement timeline is a massive financial risk. Now, consider the technical detail of gains and losses. This is the area where the most money is lost through silence. If your QDRO says the spouse gets $200,000 but is silent on gains and losses, the plan administrator will typically pay exactly $200,000, regardless of how long it takes to process the paperwork. If the market goes up 10% during the 3-month processing window, the employee keeps that extra $20,000. If the market goes down, the employee has to make up the difference from their remaining share. To be fair, most experts recommend including language that says the amount shall be adjusted for investment earnings and losses to ensure both parties share the market risk proportionally until the funds are moved. Another step-by-step detail involves the 401k loan offset. Imagine Michael had taken a $50,000 loan from his 401k in 2025 to pay for a home renovation in Henderson. At the time of the divorce in 2026, his account balance is $1.2 million, but $50,000 of that is actually a debt he owes to himself. When the QDRO is drafted, the lawyer must decide if the spouse's share is calculated based on the total balance including the loan, or just the liquid cash in the account. If the QDRO doesn't explicitly mention the loan, the plan administrator might default to a calculation that unintentionally gives the ex-spouse a windfall or leaves them shortchanged. This is not a hypothetical issue. It is a primary cause of litigation in Sunbelt courts. We must also talk about the administrative fees. In 2026, many large 401k providers have started charging significant fees to review and process a QDRO, sometimes ranging from $500 to $1,500. The QDRO itself must state who is responsible for this fee. If it is silent, the plan administrator might deduct it entirely from the employee's remaining balance or split it 50-50. While $1,000 might seem small compared to $1 million account, these small oversights contribute to the friction and animosity that can derail an otherwise civil divorce. The workflow for a successful 401k division in the Sunbelt looks like this. Step 1. Obtain the model QDRO language directly from the plan administrator. Every major company has a preferred template. Using their template makes approval much more likely. Step 2. Draft the order and send it to the plan administrator for pre-approval before it is ever signed by a judge. This avoids the nightmare of having a judge sign an order that the plan later rejects. Step 3. Once pre-approved, get the judge's signature and a certified copy from the court clerk. Step 4. Send the certified copy back to the plan administrator for final execution. But even with a perfect QDRO, there is a final massive hurdle that most people aren't prepared for: the tax execution. In the Sunbelt, where people are often looking for immediate liquidity to buy a new home or start over, the temptation to take a cash distribution from the 401k during the divorce is immense. There is a very specific, one-time loophole in the tax code that allows an ex-spouse to take cash out of a 401k via a QDRO without paying the 10% early withdrawal penalty, even if they are under age 59 and a half. However, they still have to pay ordinary income tax. If you don't understand the difference between a direct rollover and a cash distribution at this stage, you could accidentally trigger a tax bill that wipes out a third of your settlement in a single year. In the next part, we are going to break down this specific cash-out strategy. Why is it often called the silver lining of a 401k divorce, and how can it be used to solve the immediate problem of high housing costs in Sunbelt cities? We will look at the exact IRS rules that allow you to bypass the early withdrawal penalty, and why doing this incorrectly could result in a permanent loss of compound growth that can never be recovered. What is the hidden cost of taking the cash now versus rolling it over? And why are some spouses in the Sunbelt choosing to take the tax hit today to avoid an even larger tax hit in the future? We are moving from the paperwork of the QDRO to the raw strategy of the IRS tax code in the next part of this masterclass. The Internal Revenue Code contains a very specific, high-stakes provision known as Section 72T(2)(c). In the world of high-asset divorce, this is often referred to as the QDRO distribution loophole, though it is a perfectly legal and documented exception to the standard rules of retirement withdrawals. To understand the power of this provision, we must first look at the standard rule. Normally, if you take money out of a 401k before you reach the age of 59 and a half, the IRS hits you with a 10% early withdrawal penalty on top of your ordinary income tax. However, when funds are distributed from a qualified retirement plan to an alternate payee pursuant to a qualified domestic relations order, that 10% penalty is waived. This is a one-time opportunity that only exists at the moment the QDRO is executed, and if you miss the window, it is gone forever. Imagine a case study involving Linda, a healthcare administrator living in Austin, Texas, in the year 2026. Austin has seen a decade of explosive growth, and the cost of housing has remained high despite various market corrections. Linda is 52 years old and is finalizing her divorce. As part of the settlement, she is awarded $500,000 from her ex-spouse 401k. Linda needs $150,000 to secure a down payment on a new home in a school district that allows her children to remain in their current environment. If Linda were to take that $150,000 out of her own IRA, she would be forced to pay a $15,000 penalty to the IRS immediately. But because this money is coming directly from the 401k through a QDRO, the $15,000 penalty disappears. However, there is a critical trap in the step-by-step execution of this strategy. For the penalty waiver to apply, the funds must be paid directly from the 401k plan to the alternate payee as a cash distribution. If Linda makes the mistake of rolling the entire $500,000 into her own personal IRA first, and then tries to withdraw the $150,000 from that IRA, she has lost the protection of Section 72E(2)(c). The IRS views the IRA as a new account, and the QDRO exception no longer attaches to it. This single clerical error is a common historical trend in Sunbelt divorces, where the rush to move money leads to a permanent loss of thousands of dollars in unnecessary penalties. We must also analyze the mandatory 20% federal withholding. Even though the 10% penalty is waived, the distribution is still considered ordinary income. Federal law requires the 401k plan administrator to automatically withhold 20% of any cash distribution and send it directly to the IRS. In Linda's case, if she requests $150,000 in cash, the plan administrator will send her a check for $120,000 and send $30,000 to the IRS. This creates a liquidity problem. If Linda actually needs $150,000 for her down payment, she must gross up her request. She would need to request approximately $187,500 to receive a net check of $150,000 after the mandatory withholding. This leads to a deeper mathematical problem: the impact on her 2026 tax bracket. Adding $187,500 of ordinary income to her existing salary could push Linda into a much higher tax bracket. If her effective tax rate ends up being 32%, the 20% already withheld won't be enough. She will owe an additional 12% when she files her taxes in April 2027. In the Sun Belt, where states like Texas, Florida, and Nevada have no state income tax, this federal hit is the only major tax concern. But for someone in California or Georgia, the state will also want its share of that distribution, further eroding the net amount. The opportunity cost of this strategy is the most significant long-term factor. We are currently in an era where the historical trends of the S&P 500 suggest an average annual return of roughly 7 to 10% over long periods. If Linda takes $187,500 out of her retirement system at age 52, she isn't just losing that cash today. She is losing 13 years of compound growth before she reaches age 65. At a 7% return, that $187,500 would have potentially grown to over $450,000 by the time she retired. By using the QDRO to solve a 2026 housing problem, she is effectively spending nearly $500,000 of her future self's money. This is why the deep dive into 401k division requires looking at the alternative, the asset swap or the offset strategy. In many Sunbelt divorces, the spouse with the 401k wants to keep the account intact to preserve that compound growth, while the other spouse wants a different asset, such as the equity in the primary residence. This is where the calculation of the tax-adjusted value becomes paramount. $1 in a 401k is not equal to $1 of home equity. Imagine if Linda's husband has $500,000 in his 401k, and they also have $500,000 of equity in a home in Summerlin, Nevada. A simple split would be for him to keep the 401k and her to keep the house. On the surface, this looks like a 50-50 split. But in 2026, the tax implications tell a different story. If the husband retires and begins withdrawing from the 401k, he might only net $375,000 after taxes. Meanwhile, if Linda sells the house, she can often exclude up to $250,000 of gain from her taxes under current IRS rules for a primary residence. Linda walked away with $500,000 of real value, while the husband walked away with $375,000 of real value. In a professional Sun Belt settlement, experts will use a tax-affected valuation. They will discount the value of the 401k by an estimated future tax rate, perhaps 20 or 25%, to reach a present value that can be compared to other assets. If the 401k is valued at a discount, the person keeping the 401k might also be entitled to a larger share of other assets to make the deal truly equitable. This level of detail is what separates a standard divorce from a masterclass level financial restructuring. We also have to consider the risk of the in-kind distribution. Some 401k plans, particularly those for employees of large corporations in the Sunbelt's aerospace or technology sectors, allow for the transfer of actual shares of stock, rather than just cash. This introduces the concept of net unrealized appreciation or NUA. If the 401k holds highly appreciated company stock, transferring those shares through a QDRO can sometimes allow the recipient to eventually pay capital gains tax rates on the growth, rather than the much higher ordinary income tax rates. In 2026, as tax policy continues to be a central point of political and economic debate, the delta between capital gains and ordinary income can be the difference between a comfortable retirement and a lean one. The step-by-step logic for the cash-out strategy remains a powerful tool, but it must be used with surgical precision. Step 1. Identify the exact net amount needed. Step 2. Calculate the gross-up required to account for the mandatory 20% withholding. Step 3. Analyze the total tax impact on the 2026 filing year. Step 4. Ensure the QDRO language explicitly allows for a partial or full cash distribution directly to the alternate payee. Step 5. Verify that the plan administrator can execute the payment before any rollover to an IRA occurs. As we move forward, we have to look at the other side of the coin. What happens if you are the one trying to prevent the division of your 401k? What legal defenses exist to protect your retirement from being carved up? In the Sun Belt, there are specific arguments regarding the separate property nature of certain contributions and the impact of Social Security offsets in states where public employees don't participate in the federal Social Security system. How do you handle a 401k when one spouse has a massive pension and the other only has a 401k? Why does the windfall elimination provision, or the government pension offset, suddenly become a factor in your 401k division if you worked a civil service job in a state like Florida or Texas? We are going to explore the intersection of 401ks and government benefits, a topic that catches thousands of Sun Belt retirees off guard every year, in the next part of this deep dive. To understand the intersection of 401ks and government benefits in the Sun Belt, we have to address a structural anomaly that catches thousands of families off guard every year. In states like Texas, Florida, and Georgia, a massive percentage of the workforce consists of public employees, teachers, firefighters, police officers, and municipal workers. Many of these individuals do not participate in the federal Social Security system. Instead, they contribute to state-run retirement systems like the Teacher Retirement System of Texas or the Florida Retirement System. When one spouse has a traditional corporate 401k and the other has a government pension or a 403b, the divorce court faces a mathematical crisis that can lead to wildly different potential outcomes depending on the specific zip code of the courthouse. Imagine a case study involving Mark, a high school principal in Plano, Texas, and his spouse, Elena, a senior project manager for a telecommunications firm in Dallas. It is 2026, and they are ending their 20-year marriage. Elena has a 401k valued at $900,000. Mark has a state pension that will pay him $5,000 a month for life starting at age 60. But he has zero Social Security credits because his school district opted out of the federal system decades ago. In a standard Sun Belt divorce, Elena's attorney might argue that her 401k is a marital asset that should be split 50-50. However, if the court splits the 401k but leaves Mark's pension untouched, or if Mark's pension is divided but Elena keeps her future Social Security benefits entirely to herself, the result is a massive financial imbalance. This is where the Social Security offset comes into play. Because Social Security benefits themselves are technically non-divisible under federal law, due to the anti-alienation provisions of the Social Security Act, Sun Belt judges often have to engage in a form of judicial gymnastics to reach an equitable result. In some jurisdictions, the court will calculate the present value of the Social Security benefits the corporate spouse is expected to receive, and then credit that value against the government spouse's pension or 401k share. To do this, forensic accountants in 2026 use complex actuarial tables to determine the present value of a future stream of income. The formula often looks like this: PV equals T equals K, sigma, N, 1 plus I, T, PMT. In this equation, PV represents the present value of the retirement stream, PMT is the projected monthly or annual payment, I is the discount rate, often based on current 2026 Treasury yields or inflation-adjusted figures, and T represents the time periods until the end of the recipient's life expectancy. If Elena's projected Social Security is worth a present value of $300,000, a Texas judge might decide that Mark is entitled to a larger portion of the $900,000 401k to compensate for the fact that he will never receive that federal safety net. This is not a guess. It is a calculated offset based on historical trends in equitable distribution and community property adjustments. However, we must also look at the impact of the windfall elimination provision, or WEP, and the government pension offset, or GPO. These are federal laws designed to prevent government workers from receiving a full Social Security check, in addition to a substantial government pension. In our 2026 case study, if Mark did work enough side jobs to qualify for some Social Security, the WEP would drastically reduce his benefit. If the divorce settlement doesn't account for this reduction, the math used to divide the 401k will be fundamentally flawed. A common historical trend in the Sunbelt is for attorneys to overlook the WEP/GPO impact, leading to a situation where the government employee is forced to give up half their 401k or pension based on a Social Security benefit that will later be slashed by the federal government. Step by step, the analysis for a 401k division involving a public sector spouse should follow this logic. Step 1. Verify the Social Security status of the government entity. Does the spouse pay into FICA? Step 2. Obtain a formal actuarial valuation of the government pension. You cannot compare a 401k balance, which is a bucket of cash, to a pension, which is a lifetime promise, without converting the pension to a present value dollar amount. Step 3. Calculate the hypothetical Social Security benefit for the government worker. This is the amount they would have received if they had been in the private sector. Step 4. Apply the offset. In many Florida cases, courts use what is known as the Kornbleth analysis, where they subtract the value of the hypothetical Social Security from the pension value before dividing the remainder as a marital asset. The stakes of these calculations are amplified by the current 2026 economic environment in the Sun Belt. With the migration of retirees into states like Arizona and Nevada hitting an all-time high, the demand for clear-cut asset division is overwhelming the court systems. Imagine if Mark and Elena were in Nevada, a community property state. If the court ignores the Social Security discrepancy, Elena could lose $450,000 of her 401k while Mark keeps his entire pension because it was earned in a state with strict protections for teacher retirement funds. This is why the characterization of the 401k as a marital asset must always be balanced against the total retirement picture, including those government benefits that stay off the balance sheet. Another layer of this deep dive involves the 457B and 403B plans. Many Sunbelt government employees have these 401k style accounts in addition to their pensions. Unlike the pension, these accounts are often divided via a QDRO or a similar instrument like a COAP, court order acceptable for processing. However, the rules for a 457B are different. For instance, the 10% early withdrawal penalty we discussed in Part 5 usually does not apply to 457B plans, even for a standard withdrawal. This makes a 457B account a much more liquid and valuable asset in a divorce settlement than a traditional 401k. If you are negotiating a settlement in 2026, you would much rather have $100,000 from a 457B than $100,000 from a 401k because of that inherent flexibility. Consider the scenario of a firefighter in Orlando, Florida. He has a 457B with $200,000 and a pension. His spouse has a 401k with $200,000. On paper, it's a wash. But in reality, the firefighter's 457B is superior because it offers penalty-free access to cash. In an equitable distribution state like Florida, a savvy attorney will argue that the 401k holder should receive a greater share of other assets to compensate for the lack of liquidity in their retirement account. As we look toward the potential outcomes of these cases, we see a growing trend of retirement parity arguments. Judges are becoming less interested in a simple 50-50 split of each account and more interested in ensuring both parties leave the marriage with a similar projected monthly income in their 80s. This requires a level of financial literacy that most people do not possess when they first walk into a lawyer's office. It requires understanding that your 401k is not just an account. It is a piece of a larger puzzle that includes Social Security, state pensions, and federal tax law. But what happens when the 401k itself becomes a liability? What if there are hidden loans? Or what if the account is frozen by the plan administrator for months on end during the QDRO process? In the Sunbelt, where people often move and change jobs frequently, the lost 401k from a previous employer can become a nightmare to track down and divide. How do you find a 401k from a company that went bankrupt or merged 3 times since you worked there in the 2010s? What happens to the division of assets if one spouse took a secret loan against the 401k just weeks before filing for divorce? And why is the frozen account the most dangerous period for your investment portfolio during a Sunbelt market swing? We are going to explore the world of hidden 401k liabilities and the administrative hold period that can trap your money for months in the next part of this masterclass. The administrative hold is the silent killer of retirement value in a Sunbelt divorce. The moment a 401k plan administrator receives notice that a divorce is pending, whether through a formal joinder in California or a notice of adverse interest in states like Arizona or Nevada, the account enters a state of digital cryostasis. This is a protective measure intended to ensure that the participant spouse does not liquidate the account or change beneficiaries before the court can rule on the division. However, in the high volatility environment of 2026, being unable to move your money for 6 to 9 months while the legal system grinds through paperwork can lead to catastrophic potential outcomes. Imagine a case study involving Maria, a pharmaceutical executive in Phoenix, Arizona. Maria has a 401k balance of $1.4 million in early 2026. Her portfolio is heavily weighted toward aggressive growth tech stocks, which have performed exceptionally well over the last 5 years. When she and her spouse file for divorce, the plan administrator places an immediate administrative hold on her account. This means Maria cannot sell her positions, she cannot rebalance into more conservative bonds, and she cannot move her holdings to a stable value fund. 2 months into the hold, a significant market correction occurs, and tech stocks drop 20%. Because Maria is legally locked out of her own account, she watches $280,000 of her retirement value vanish in a matter of weeks with no way to mitigate the loss. Historical trends show that during the hold period, the participant spouse bears all the market risk while having none of the control. If the divorce decree eventually awards the ex-spouse 50% of the account as of the date of filing, Maria might be forced to pay out a sum based on the $1.4 million valuation, even though the account is now only worth $1.12 million. In this scenario, she isn't just losing half, she is losing nearly 70% of the actual remaining value because of the timing of the freeze. To navigate this, the step-by-step strategy for 2026 involves a proactive request for a limited release of the hold. A savvy attorney can sometimes negotiate a stipulated order that allows the participant to move the entire balance into a cash equivalent or money market fund within the 401k until the QDRO is finalized. This effectively stops the bleeding and locks in the dollar amount for both parties, removing the element of market gambling from an already stressful process. Without this intervention, you are essentially a passenger on a ship you can no longer steer, headed straight into whatever economic storm the 2026 market decides to throw your way. Now we must address the hidden liability of the secret 401k loan. In the Sunbelt, where the cost of living in cities like Miami and Austin has put immense pressure on household liquidity, many employees have turned to 401k loans to cover short-term expenses. The problem is that a 401k loan is not a standard debt. It is a withdrawal of your own money that you are obligated to pay back with interest. When a divorce occurs, this loan creates an accounting nightmare. Consider a case study of Jason, a construction manager in Tampa, Florida. Jason took a $50,000 loan from his 401k to renovate a rental property in late 2025. When he and his spouse divorce in 2026, his 401k statement shows a balance of $500,000. However, that $500,000 includes the $50,000 loan he still owes. In the eyes of the plan administrator, the account value is indeed $500,000, but in reality, only $450,000 is liquid. If the court orders a 50-50 split without accounting for the loan, the ex-spouse expects $250,000 in cash. If the plan administrator extracts that $250,000 from the liquid $450,000, Jason is left with $200,000 in cash and a $50,000 debt. To make matters worse, if Jason loses his job or can no longer make the loan payments after the divorce, the $50,000 is considered a taxable distribution. He would then owe ordinary income tax on that money, and potentially an early withdrawal penalty, despite the fact that half of the original account value is now in his ex-spouse's pocket. Historical trends in Sun Belt litigation indicate that judges are increasingly viewing these loans through the lens of dissipation of marital assets. If Jason took that loan without his spouse's knowledge or used it for a non-marital purpose, the court might credit the entire $50,000 debt to his side of the ledger. The step-by-step logic for discovery here is to look specifically for the 1099, R forms and the itemized payroll deductions on the participant's pay stubs. If you see a recurring deduction labeled 401k-LN, you have found a hidden liability that must be addressed in the settlement language before the QDRO is ever drafted. Beyond hidden loans, we have the epidemic of the lost 401k. The Sunbelt is defined by its transient workforce. In 2026, the average professional in Dallas or Charlotte has changed jobs 4 times in the last decade. Many of these individuals leave behind small or medium-sized 401k accounts with former employers, often forgetting they exist as they move from state to state. In a divorce, these accounts are still marital property if they were earned during the marriage. If you fail to disclose these accounts, you are committing a form of financial fraud that can lead to the entire account being awarded to your spouse years later when it is inevitably discovered. The process of tracking down these abandoned assets has become more streamlined in 2026 thanks to federal databases mandated by the Secure Act 2.0, the National Registry of Unclaimed Retirement Benefits, and the Department of Labor's Abandoned Plan Search are essential tools. You should also look at old tax returns for Form 5500 filings or 1099, or distributions from years past. Imagine if a spouse in Nevada finds an old 401k from a California tech job worth $100,000 that was never disclosed. Under many Sunbelt state laws, the court can reopen the case to divide that asset, and the legal fees for the omitted asset litigation can easily exceed the value of the account itself. We must also consider the complication of the bankrupt or merged employer. If you worked for a startup in Austin that went bust in 2023, your 401k didn't just disappear. It was likely moved to a successor plan or a terminal trust. Finding the current fiduciary of that plan is a specialized task. If the plan was a defined benefit pension rather than a 401k, it might now be under the control of the Pension Benefit Guaranty Corporation, PBGC. Dividing a PBGC-controlled account requires a different set of orders than a standard QDRO, adding another layer of technicality to your 2026 divorce strategy. The step-by-step logic for securing these lost or hidden assets begins with a thorough review of the Social Security Administration's earnings statement. This document lists every employer you have ever had. By cross-referencing this list with your marriage dates, you can identify every potential 401k that was contributed to during the marital years. Once the list is established, you must send a request for information to each plan sponsor to determine the current balance and the status of any outstanding loans. As we move deeper into this masterclass, we have to look at the psychological and tactical warfare that often surrounds the 401k. While the numbers are objective, the way they are presented to a judge can vary wildly. One spouse might argue the 401k should be valued as of the date of separation to avoid sharing in a recent market rally, while the other argues for the date of the decree to capture those gains. In the Sunbelt, the choice of a valuation date is one of the most litigated aspects of retirement division. How do you win the battle over the valuation date when the law is ambiguous? What happens if your spouse attempts to liquidate their 401k and move the money into an offshore cryptocurrency account before the administrative hold is in place? And why is the concept of tracing your premarital contributions the most expensive and frustrating part of a high-net-worth divorce in 2026? We are going to explore the high-stakes world of forensic accounting and the battle of the experts in the next part of this deep dive. In the high-stakes world of forensic accounting, the burden of proof is the most expensive variable you will encounter during a Sunbelt divorce in 2026. If you are the spouse claiming that a portion of your 401k is separate property, the law does not start from a neutral position. In community property states like California, Nevada, and Texas, the legal system operates under the community presumption. This means that every cent in that 401k is legally considered marital property until you provide clear and convincing evidence to the contrary. If your records are incomplete, if you have lost the login to a portal from 10 years ago, or if your previous employer's HR department has purged their files, the court will likely default to the simplest math: a 50-50 split of the entire balance. This is where the battle of the forensic experts begins. To protect your premarital assets, you must engage in a process known as tracing. Imagine if you took a pound of ground beef that you owned before the marriage and mixed it with a pound of ground pork that you bought during the marriage. Once they are combined in the bowl, can you accurately separate every molecule of beef back into its original pile? In the eyes of a Sunbelt judge, your 401k is that bowl of mixed meat. Tracing is the scientific process of proving which molecule is which. Imagine a case study involving David, a senior executive at a renewable energy firm in Austin, Texas. David has a 401k valued at $2.2 million in 2026. He started the account in 2004, but he didn't marry his spouse until 2014. David assumes that the 10 years of contributions he made before the wedding are his to keep. However, over the 22 years of the account's life, David has changed investment allocations dozens of times. He has rolled over funds from 3 different sub-accounts, taken 2 loans for a vacation home in Sedona, and received varying levels of company matches. His spouse's forensic accountant will argue that the funds are so hopelessly commingled that they have undergone transmutation. This is a legal term in the Sun Belt that describes the process of separate property becoming community property through the lack of distinct boundaries. If David cannot produce every single monthly or quarterly statement from 2004 to 2014 to establish the exact inception of title and the subsequent growth, the court may rule that he has failed his burden of proof. In 2026, many Sun Belt courts are becoming less lenient with missing records, arguing that in the digital age, a failure to maintain financial records is a choice rather than an accident. Forensic accountants use several methodologies to attempt this separation. The first is the clearinghouse method. This involves treating the 401k like a bank account where every contribution is tracked as a specific deposit. The expert must calculate the internal rate of return for the separate portion versus the community portion. If the S&P 500 grew by 12% in 2019, the expert must determine exactly how much of that 12% gain is attributable to the pre-2014 dollars and how much is attributable to the post-2014 dollars. This is not a simple linear calculation because the community contributions are added every 2 weeks with every paycheck, creating a compounding effect that favors the community side. The second methodology is the family expense presumption. This is often used in California and Arizona. It assumes that if any money was taken out of the 401k, for example through a loan or a hardship withdrawal, those funds were taken from the community portion first. If the withdrawal exceeded the community portion, only then did it dip into the separate property. This can be a double-edged sword. While it might protect the separate principal, it requires an exhaustive audit of every household expense paid for by that withdrawal to prove its marital nature. Then we must look at the distinction between active and passive appreciation. This is one of the most litigated nuances in Sun Belt retirement law. Passive appreciation is the growth of the account due to market forces alone. If you owned 1,000 shares of an index fund before the marriage and those shares grew in value without you ever touching the account, that growth is generally considered separate property in most jurisdictions. However, active appreciation occurs when the growth is the result of the labor, effort, or skill of one of the spouses during the marriage. In a 2026 historical trend, attorneys for the non-employee spouse are increasingly arguing that if the participant spouse was an active trader, logging into their 401k brokerage link every week, researching stocks, and moving money between sectors, they were using community time and effort to grow the account. Therefore, the growth is no longer passive. It is a marital asset. This argument is particularly effective in tech-heavy regions like the Silicon Hills of Austin or the Tech Corridor in Northern Virginia. If the expert can prove that David's active management resulted in an alpha or an outperformance of the general market, the spouse might be entitled to a portion of that outperformance as a reward for the community effort. The cost of this forensic battle is a major factor in the potential outcomes. In a high-net-worth Sun Belt divorce, it is not uncommon for each spouse to hire their own forensic accountant at rates exceeding $600 per hour. By the time they have reconstructed 20 years of data, the bill for the experts alone can reach $50,000 to $100,000. This creates a strategic standoff. If the amount of separate property David is trying to protect is only $200,000, spending $100,000 to prove it is a net loss when you factor in the emotional toll and the delay in the case. Many settlements in 2026 are reached not because the math is settled, but because the cost of the math has become unsustainable for both parties. Step by step, the discovery process for tracing looks like this. Step 1. The issuance of a comprehensive document request for all 401k plan documents, including the summary plan description and all individual statements since the date of inception. Step 2. The identification of any rollover events. A rollover is a point of extreme vulnerability. If you moved money from a 401k into an IRA or into a new employer's 401k during the marriage, that event often serves as a reset button for the community presumption. Step 3. The expert builds a spreadsheet that applies the specific state's tracing rules, such as the Hunt formula or the Thomas formula, to every transaction. Step 4. The expert issues a formal report, which is then challenged by the opposing expert in a deposition. This battle over the characterization of the 401k is the precursor to the final execution of the division. Once the judge or the mediators have decided what percentage belongs to whom, we move into the actual mechanics of the transfer. But there is a final trap that even the best forensic accountants sometimes miss. It is the issue of the frozen liquidity and the timing of the payout. If you win the battle of characterization but lose the war of timing, you can still find yourself with a hollow victory. What happens if the court awards you a specific dollar amount based on a 2026 valuation, But the 401k company takes 6 months to process the QDRO while the market is in a tailspin. Who is responsible for the shortfall? And why is the person who receives the money often in a better position than the person who keeps the account, even if the dollar amounts are identical? We are going to explore the final execution phase and the hidden risks of the post-divorce 401k management in the next part of this masterclass. The final execution phase of a 401k division is where the theoretical victory of a courtroom settlement meets the cold, uncompromising reality of financial operations. Most people believe that once the judge hammers the gavel in a courthouse in Tampa or Las Vegas, the deal is done. In reality, you are entering a high-risk transition period that can last anywhere from 3 to 9 months. In the year 2026, the administrative gap has become a significant source of post-divorce litigation in the Sun Belt because of the sheer speed at which modern markets move. If you do not understand the mechanics of how that money actually travels from one account to another, you could find yourself holding a decree for $1 million that only results in a payout of $800,000. Imagine a case study involving a character named James, a logistics manager for a major distribution hub in Savannah, Georgia. In early 2026, James and his spouse finalized their divorce. The settlement agreement is clear. His spouse, Sarah, is awarded exactly $500,000 from James's $1.2 million 401k. The judge signs the decree on March 1st. However, the Qualified Domestic Relations Order, or QDRO, still needs to be drafted, reviewed by the plan administrator, signed by the judge, and then processed by the financial institution. This process takes until June 1st. During those 3 months, the market experiences a sharp 15% correction. Because the order was for a specific dollar amount of $500,000, the plan administrator must fulfill that exact amount for Sarah. The $180,000 market loss on the total account is borne entirely by James. His remaining $700,000 share is suddenly reduced to $520,000. James is left with a far smaller piece of the pie than he originally negotiated, simply because of a drafting choice. Historical trends in Sun Belt jurisdictions like Texas and Florida show a shift toward using percentage-based awards to mitigate this risk. If James's attorney had drafted the order to award Sarah 41.6% of the account, which was the equivalent of $500,000 on the day of the decree, both parties would have shared the 15% loss proportionally. Sarah would have received $425,000, and James would have kept $535,000. While both lost money, the equitable nature of the split remained intact. In a deep dive masterclass context, the first step-by-step rule for 2026 is this. Always include language that specifies whether the award is a fixed dollar amount or a percentage, and explicitly state whether that award includes pro rata earnings and losses from the date of valuation until the date of distribution. There is a psychological trap here as well. The spouse receiving the money, the alternate payee, is often in a much stronger financial position post-divorce than the participant spouse, even if the dollar amounts are identical. This is because of the fresh start advantage. When the funds are moved via a QDRO into Sarah's new 2026 IRA, she has total control. She can immediately rebalance her portfolio, move into low-cost index funds, or shift to a conservative cash position to protect her settlement. James, however, is often stuck. He may still be subject to the limited, high-fee investment options offered by his employer's 401k plan. He might also be restricted by the administrative hold we discussed in Part 7, preventing him from adjusting his remaining balance until the entire QDRO process is finalized. Potential outcomes for the participant spouse often involve being locked into a sinking portfolio, while the ex-spouse sails away on a newly diversified ship. We must also analyze the massive risk of the 60-day rollover trap. In 2026, the IRS has become increasingly strict with indirect rollovers. If the 401k plan administrator cuts a check directly to the alternate payee instead of doing a direct trustee-to-trustee transfer to an IRA, the clock starts ticking immediately. You have exactly 60 days to get that money into a qualified retirement account. If you miss that window, perhaps because of a mail delay or a simple misunderstanding of the paperwork, the IRS treats the entire amount as a taxable distribution. For a $500,000 payout, this could trigger a tax bill of over $150,000 in a single year. Furthermore, as we noted in Part 5, the plan is required to withhold 20% for federal taxes on an indirect distribution. This means Sarah would only receive a check for $400,000, but to avoid taxes and penalties, She would have to find an additional $100,000 from her own pocket to deposit the full $500,000 into her IRA within those 60 days. If she cannot find that $100,000, that portion is considered a permanent distribution, taxed, and potentially penalized. Step by step, the safest way to execute the transfer is the direct rollover. You must provide the 401k plan administrator with the exact account number and the clearinghouse information for your new IRA. The money should never touch your personal bank account. In the Sunbelt, where many people are moving between states during a divorce, ensure that your mailing address is updated and that you have a digital confirmation of the transfer. Historical trends show that lost checks or misdirected wires are the primary cause of the 60-day rule violations. Another hidden risk is the death of a party during the administrative gap. Imagine if James passes away after the divorce decree is signed but before the QDRO is officially qualified by the plan administrator. Under ERISA, if there is no qualified QDRO on file, the 401k plan might revert to the designated beneficiary on the account. If James never updated his beneficiary from his ex-spouse to his children, the ex-spouse might receive 100% of the account by operation of law, overriding the divorce decree. Conversely, if he had updated it to his children, the ex-spouse might receive nothing, despite the court order. To prevent this, 2026 legal experts recommend including a nunc pro tunc clause in the QDRO, which asks the court to treat the order as if it were effective on the date of the divorce decree, providing a layer of protection against the unexpected death of either party. Consider the impact of investment fees in the post-divorce landscape. Many 401k plans in the Sunbelt, particularly those for mid-sized construction or service firms, carry internal expense ratios and administrative loads that can eat up 1 to 2% of your balance every year. When an ex-spouse rolls their share into a modern low-fee IRA, they are immediately boosting their long-term compound growth by reducing those friction costs. The participant spouse, however, remains burdened by those fees on their remaining balance. Over a 20-year period, this 1% difference in fees can result in a $200,000 gap in retirement wealth. The division of a 401k is not just about the balance on the day of the divorce. It is about the divergent paths those two halves of the money will take over the next 2 decades. As we reach the final stages of this masterclass, we have to look at the long-term recovery. Dividing your 401k is a massive blow to your retirement timeline, but it is not the end of the story. There are specific IRS rules that allow you to catch up, provided you understand how to leverage your new tax status. How do you rebuild a 7-figure nest egg after losing half of it in your 50s? What are the specialized contribution limits for those who have undergone a QDRO division? And what is the one strategy involving a health savings account that many Sunbelt residents are using to supplement their depleted 401ks? The journey from a $1.2 million account to a $600,000 account is painful, but the strategy for the comeback is just as technical as the strategy for the divorce. In the final part of this series, we are going to build the ultimate 401k divorce checklist. We will summarize the critical deadlines, the tax-saving maneuvers, and the step-by-step plan to ensure that your remaining assets grow faster and more efficiently than ever before. We are moving from the destruction of the marital estate to the reconstruction of your personal financial empire. In the final part of this deep dive, the reconstruction of your financial empire after a Sunbelt divorce begins with a cold, analytical assessment of the damage and a shift in your tax strategy for the year 2026. When you lose half of your 401k, you aren't just losing the present value. You are losing the future compound interest that was projected to carry you through your 80s. However, the IRS code provides specific mechanisms for recovery that are often underutilized by those reeling from a settlement. The 2026 landscape is particularly unique due to the full implementation of the Secure Act 2.0, which has introduced higher catch-up contribution limits and new rules for employer matches that can significantly accelerate your rebuilding phase. The first step in your reconstruction plan is the mandatory beneficiary audit. Historical trends show that many divorcees in states like Florida or Arizona successfully navigate the QDRO process only to leave their ex-spouse as the designated beneficiary on their remaining 401k balance. Under ERISA, a beneficiary designation on a 401k typically overrides a will or even a divorce decree. If you pass away in 2027 without updating your beneficiary form, the plan administrator may be legally required to send your entire remaining balance to your ex-spouse, regardless of the divorce settlement. You must contact your HR department or plan portal immediately to update your primary and contingent beneficiaries. This is not just a clerical task. It is the final legal seal on your separate financial life. Next, we must look at the catch-up contribution mechanics for 2026. If you are age 50 or older, you are eligible for catch-up contributions. However, under the 2026 rules, if you earn over $145,000 a year, your catch-up contributions to a 401k must be made on a Roth basis. This means you are contributing after tax dollars, but the growth in future withdrawals will be tax-free. For someone in a high-growth Sunbelt hub like Charlotte or Dallas, this is a powerful tool for rebuilding. Imagine if you are 55 years old and your 401k was reduced from $1 million to $500,000. By maximizing the standard contribution limit, which is projected to be approximately $23,500 in 2026, plus the catch-up limit of $7,500, you are moving over $30,000 a year into a tax-advantaged environment. If your employer provides a match, that money is now being applied to a smaller base, meaning your personal rate of return on those new dollars is effectively doubled by the match. Step by step, you should also leverage the Health Savings Account, HSA Stealth IRA strategy. In the Sunbelt, where healthcare costs in retirement are a primary concern for residents in states like Florida, the HSA is the most tax-efficient vehicle available. In 2026, the contribution limits for HSAs have increased. Because an HSA offers a triple tax advantage: tax-deductible contributions, tax-free growth, and tax-free withdrawals for medical expenses. It acts as a supplementary retirement account. If you pay for your current medical expenses out of pocket and allow the HSA to grow in a diversified stock portfolio, you are creating a secondary nest egg that can be used penalty-free for any purpose after age 65, though non-medical withdrawals are taxed as ordinary income. For a divorcee looking to replace a lost 401k, the HSA is a critical component of the recovery puzzle. Let's look at a final case study involving Catherine, a 62-year-old consultant in Boca Raton, Florida. In early 2026, Catherine's divorce was finalized, and her $1.5 million 401k was split 50-50. She was left with $750,000. Catherine utilized the new Secure Act 2.0 provision that allows for an even higher catch-up limit for individuals aged 60 to 63. In 2026, she was able to contribute $11,250 in catch-up funds alone. Furthermore, because Florida has no state income tax, every dollar she moved into her 401k or HSA saved her the full federal marginal rate. By aggressively rebalancing her remaining $750,000 into a more aggressive growth posture, acknowledging that her timeline for retirement might have to extend by 3 to 5 years, Catherine was able to model a potential outcome where her account could return to its original $1.5 million value within 7 to 9 years, assuming historical market trends of 7% annual growth. The 401k divorce reconstruction checklist for the Sunbelt should be your go-to guide as you move forward. Execute the direct rollover. Ensure the funds awarded to you are moved via a trustee-to-trustee transfer to avoid the 60-day tax trap. Recalculate your risk tolerance. Your investment strategy as a single person in 2026 may need to be more aggressive than it was as part of a couple, as you no longer have a spouse's income or retirement account as a safety net. Verify the cost basis. If you received company stock through a QDRO, document the original cost basis for future net unrealized appreciation, NUA tax treatment. Update your estate plan. A 401k is only one piece. Your power of attorney, living will, and trusts must be aligned with your new status as a single filer. Leverage the single filer tax brackets. Work with a tax professional to see if a Roth conversion of your remaining 401k funds makes sense while you are in a potentially lower tax bracket immediately following the divorce. Historical trends suggest that the period immediately following a divorce is the most common time for individuals to make impulsive financial decisions, such as liquidating a 401k to buy a luxury property in Scottsdale or a boat in the Keys. We have seen case studies where individuals use their 401k settlement to fund a lifestyle that they could no longer afford, leading to a total depletion of retirement assets within 5 years. The goal of this masterclass is to prevent that outcome by focusing on the mathematical reality of compound interest and the technical advantages of the U.S. tax code. Imagine if you treat your post-divorce 401k as a new business venture. You are the CEO, and your mission is to optimize every dollar for efficiency. In the Sunbelt, the opportunities for growth are immense, but the legal and tax pitfalls are equally significant. By following the step-by-step logic of the QDRO, avoiding the early withdrawal penalties, and maximizing the 2026 catch-up provisions, you are not just surviving a divorce, you are engineering a financial second act that can be even more robust than the first. This concludes our 10-part deep dive into the 401k divorce in the U.S. Sun Belt. You now have the technical depth, the historical context, and the step-by-step strategies needed to navigate one of the most complex financial events a person can face. However, the 401k is only half of the story in the Sun Belt. In this region, real estate is often the primary vehicle for wealth, and the way a home is treated in a divorce is fundamentally different from a retirement account. What happens to your Florida homestead exemption when you move out during a separation? How do you handle the massive capital gains hit on a property in Austin that has tripled in value since you bought it? And why is the mortgage buyout trap the next major hurdle for Sunbelt divorcees in 2026? We are moving from the world of liquid retirement accounts into the high-stakes world of Sunbelt real estate and the house-rich, cash-poor divorce trap in our next masterclass series.